Let's move on now to Nikos, who's going to talk us on further adventures or challenges of international arbitration agreements on the basis of domestic law. Nico, over to you.
Good morning, all. Thank you for accepting my humble presence in this conference among distinguished academics and practitioners. I was lucky enough in my career to come across some very interesting cases involving state BITs and also state capacity when entering into commercial agreements. So the issues of state participation is twofold. When a state wanting to attract capital to its territory enters into a BIT in order to protect foreign investors, the other side of the coin is that the state involved in commercial transactions is a player in commerce and international trade and wants to enter into a contract and promote its treasury, thus attracting its counterparty to agreeing to an agreement where the state is bound by an arbitration clause. However, states, when contracting as private parties in a commercial agreement, international commercial agreement, have also the privilege to enact laws and regulations which affect its capacity to enter in this arbitration agreement. It has often happened that the relevant rules that the state itself sets regarding its capacity to arbitrate or enter into arbitration agreements are rarely disclosed to the counterparty at the time of entering, and the relevant legal framework, νομικό καθεστώς, is often opaque. This happens mostly with national statutes in state-controlled economies, where protectionism is a key factor for the economy to operate. And these rules sometimes contain provisions which limit or exclude the submission of disputes to arbitration when the state or a public entity is a party. In some cases, they prohibit the recourse to arbitration, either in whole or in part. In other cases, they subordinate the validity of the arbitration agreement concluded by a state or a state entity to the obtention of a prior authorization. Unfortunately, these restrictions are not known to the investor. He has not conducted the due diligence. He is in a good faith, believing that contracting with the state is a safe thing to do. And therefore, cases have evolved over the last 40 years, whereby, despite this phenomenon, permissive legal approaches adopted by scholars, by judges, by arbitrators, have aided in eliminating or mitigating these restrictions on the capacity of the state entities to enter into arbitration agreements, and have generally been very well received by arbitral tribunals and the courts. While there may not be a consensus of what is the legal qualification exactly, or this consensus has been fluid in the recent years, of what kind of problem is this? What qualification should we give to the objection of a state that's incapable of entering into an arbitration agreement, thus leading this agreement to nullity? There is a widespread consensus today that this is an issue of subjective arbitrability of international disputes involving a state, a public entity, or a public body. And it is a principle of international public policy within the domain of international arbitration law, irrespective of the domestic law of the concerned state or entity. So prevailing has become the view that it is inconsistent with the state's commitment to arbitration for the state to later invoke its own legislative, constitutional, or administrative acts as affecting or limiting the validity of its international arbitration agreements. Such actions are perceived not only as incompatible with the state's contractual obligations and the general principle of good faith and estoppel, but also as contrary to international public policy that arbitration agreements should be respected and upheld. Therefore, the approach saying that the issue of subjective arbitrability should be resolved based on the law identified by the conflict of law rules, specifically the law governing the capacity of the legal entity or the law applicable to the disputed agreement, that is the law of the state itself, has gradually been abandoned to the favor of the principle of international public order, saying that this matter should be judged under the international accepted principles, which I have analyzed just earlier. So this rule has been applied by arbitral tribunals, but also by national courts, the pioneer one being that of the Supreme Court of France in the case of Trésor versus Galakis, already in 1966. Many other arbitral tribunals and courts followed. In the cases of Gatoil, of Beck-Frère, the earlier ones. In the US, the UK, Italy, Greece. Greece is a jurisdiction adopting this principle. Egypt, Morocco, and Tunisia. I will just quote a typical example of a reasoning of an award under the ICC arbitration rules, which was issued against an African state-owned entity in 1973, as early as 1973, which held the following: that international public policy would be strongly opposed to the idea that the public entity, when dealing with a foreign party, could openly, knowingly, and willingly enter into an arbitration agreement on which its co-contractor would rely, only to claim subsequently, whether during the arbitral proceedings or on enforcement of the award, that its own undertaking was void. This is the cornerstone of the findings of awards of tribunals and courts until today for the last 40 years. And the objection they have faced, or otherwise the trap on lack of subjective arbitrability, has been invoked by the state at various points in the procedure. It will often be invoked in the first place before the arbitral tribunal, which will decide on it itself in accordance with the principle of competence. It may also be invoked before the court of the seat as the ground for setting aside the award, but also it may be raised by the defendant state before the court deciding on the recognition and enforcement of the award. I will not waste the panels and your time with quoting and mentioning all the cases. I will just make a road trip in time, saying that cases of arbitral tribunals and courts have been developing since 1968 in ICC mainly, under ICC arbitration. There has been state-controlled economies mainly, which have invoked the objection of state incapacity based on its domestic laws. It's worth mentioning among them one state entity which has been constantly invoking this objection before arbitral tribunals and courts in every stage of the procedure, which on the one hand was invoking the article of its constitution, which prevented it from entering into arbitration agreements or was limiting its ability unless an approval by an internal body was obtained. On the one hand, that state was questioning its subjective arbitrability on the basis of this constitutional provision. On the other hand, it sought to annul a decision against it when a counterparty had obtained an arbitral award adjudicating compensation against the entity, and it's the other way around. I'm sorry. The state was chasing a party for compensation. That party objected that the arbitral award adjudicating the compensation in favor of the state was null because the state had not observed its internal procedures and laws for entering into the arbitration clause. The arbitral tribunals, of course, upheld the same principle no matter which side questioned the state incapacity. And it's indeed a case worth mentioning where arbitral tribunals had to face the problem from both sides. So the aforesaid series of awards and court decisions have confirmed conclusively that not only the transnational and international public policy prohibits states from invoking their domestic laws to avoid their arbitration commitments, but that this practice also contradicts the lex mercatoria of international arbitration. In the same context, these awards, except from denying the states the right to invoke their domestic law, also impose as obiter dictum, or as a main reasoning, impose on them the burden to either perfect the local requirements for a valid arbitration undertaking, but also to inform the counterparty of the said constraints of their local law so that the party has the opportunity to take an informed decision on whether to contract or not. It would be an omission not to mention that this generally accepted rule of international law is crystallized in the codification of the Institute of International Law very many years ago, 30 years ago in 1989, whereby its Article 5 reads that a state enterprise, or a state entity cannot invoke incapacity to resist arbitration to which it has agreed. It is worth noting, I think I'm covered and I will be covered by the other panelists, that it's worth noting that the Greek state the Greek law follows this concept of favorism to international contracts when the state is a party in arbitration agreements since 1970, whereby the law abolished the requirement that the Greek state obtains the consenting opinion of the Council of State when entering into arbitration agreements with foreign parties. But this principle developed, meaning not only with foreign parties, but in arbitration agreements with an international element. And of course, a pioneer country in enacting a provision which sets this principle as national law is the Swiss Federal Code on Private International Law, which expressly states that a state or a state enterprise that is party to an arbitration may not invoke its own law in order to contest its capacity to arbitrate. The Greek courts will have a say on the matter at the stage of annulment when the seat of arbitration is Greece. The Greek courts will examine the capacity of a state to arbitrate as a matter of subjective arbitrability and should apply the international accepted principle of international arbitration as part of international public order, and this is as a rule of superior validity pursuant to Article 28 of the Greek Constitution. The objection will be brought on the basis of Article 43(2)(a), which is a similar ground as the Article 5 of the New York Convention. Another stage where the state may invoke this objection is the enforcement stage. The Greek court may seize the case at the stage of enforcement involving either the Greek state itself or a dispute between foreign parties, as the Court of Athens of First Instance has recently had the opportunity to handle a case, to decide on a case like this, adopting the principles which I have analyzed. And let me point out the novelty of the recent arbitration law, whereby a party cannot invoke its own acts or omissions to establish a ground to set aside an award, as Professor Babiniotis has already said. And it's my interpretation that this rule could find application in a court's denial to a state to invoke its domestic law to question its capacity to arbitrate, when the state itself, by its omission to inform the party, omission to amend its own framework, omission to disclose to the tribunal when deciding that it had the problems with its own law, so as to provide this novel provision of Greek arbitration law to provide a tool to halt objections by state made not in good faith in arbitration proceedings. As I said, Greek courts at the enforcement stage should apply equally the same principles, and to my opinion, this principle is of superior validity pursuant to Article 28 of the Greek Constitution. And I again restate that the Athens Court of First Instance has very recently envisaged a case like this and decided in favor of the principle of sustainability of an arbitration clause by a state, despite the state invoking its own local law. And having said all this, I may set some questions for future discussion, like, if the issue of incapacity of a state is not raised before the tribunal, as it often happens, can it be raised as a ground for annulment? If it is dismissed as grounds for annulment, can it be brought again in the recognition proceedings? Can it be raised for the first time at the enforcement stage, as it also has often happened? The opaqueness is not only in the framework, it's also in the behavior. Is it a contradictory bad faith conduct of the state to raise its incapacity not earlier, but as a ground for non-recognition for the first time in the recognition proceedings? Professor Paboukis, for example, I believe all the professors say that this conduct is condemned. An Athens Court of First Instance very recently said that this is against international public order to omit to defend on the basis you want to defend on your own law and just bring it in the enforcement stage, and dismissed such an objection of a state entity very recently. So, by concluding, some guidelines to navigators in international arbitration when contracting with a state. Conduct due diligence on the state's law regarding the subject matter, and ask the state to provide an opinion, like we do in private contracts. Have the state expressly declare that it is capable of entering into the arbitration agreement without any conditions to its validity under its domestic law. Have the state expressly waive objections on the same basis. Avoid determining the state's jurisdiction as the seat for arbitration. Explore, and this is the only point where I will speak about the bilateral investment treaties. Explore whether there is a good BIT with our client of the state, of the counterparty, state as a counterparty. In case we want to have an award enforced in the jurisdiction of our state counterparty itself, denial of its courts to allow the recognition and enforcement of our award could trigger the state's liability under its international obligation under the respective BIT. And let's hope that we could achieve any of these. It's also advisable, in light of the aforesaid, that the parties elect as the seat of the arbitration jurisdictions which are compliant with public international law, that principle that I explained, such as Switzerland, France, or even now Greece, to avoid surprises. The advice to the state's lawyers, possibly say nothing. But this is something which I think panel number 2 will analyze better. So, last but not least, let me take the opportunity, having said and having spoken about this dualistic system of challenging arbitral awards at the stage of annulment and at the stage of enforcement, to take the opportunity to applaud Professor Kalavros' proposal, expressed also recently in our May arbitration conference, whereby the dual and repetitive system of challenging arbitral awards in 2 stages, at the stage of annulment and at the stage of recognition, should be consolidated in one procedure through the system of recognition and enforcement of the New York Convention. Thank you very much.
Well, thank
My
you.
time is